Jerry Sanstead, 897.
And appearances, please.
Scott Wolfram for the state, Your Honor.
Charlie Newman on behalf of Jerry Sanstead.
Thank you. Sir, you're here on a new case out of Superior Court for 1 count of reckless manslaughter, a Class 2 felony, 1 count of aggravated assault, a Class 3 felony, 1 count of endangerment, a Class 6 felony. Do you wish to address any probable cause issues or simply release conditions?
Release conditions, Judge.
Thank you. So the court does find probable causes to those counts. And your appearance is for all future proceedings?
Yes, Judge.
Thank you. So the court's determined that you can hire an attorney, which you've done at this point. Go ahead with release conditions, starting with the state.
Thank you, Your Honor. Your Honor, this matter involves a situation in which the subject was driving, was observed to be on his cell phone, was observed to cross over multiple lanes of traffic, striking a patrol officer in the course of his duties while conducting a traffic stop. There were flashing emergency lights on his marked police vehicle. He was hit while this vehicle crossed over lanes of traffic and then striking the vehicle that the officer had actually stopped previously. The vehicle was already in a stopped position as our subject was driving, observed on his cell phone. Apparently that covered distance, apparently never looked up, never looked to see any flashing emergency lights, and never realized that he was about to collide into a situation in which he was going to kill an officer in the course of his duties and a victim who is otherwise in his vehicle lawfully stopped by a police officer. Your Honor, the extreme recklessness and the indifference to the safety of the community in this situation by Mr. Sanstead is clear. Given that difference, that indifference, this isn't just one of the situations where a vehicle just stops short while an individual looks at their phone, which we know is dangerous enough, but rather this appears to be just a complete disregard for the safety of the community while he was driving. It resulted in the death of an individual. It resulted in injuries to another individual. The nature of the damage described to the victim vehicle is significant. The state will note there does not appear to be any impairment that was indicated in the release condition, the probable cause statement. There were no brake marks or skid marks. This was completely a surprise to Mr. Sanstead when he struck this situation. There's nothing else to indicate that he was having any difficulties outside of just pure inattention, including being interviewed afterwards and his admissions as to what the nature of what he was doing, Your Honor. Accordingly, due to the nature of the allegations, due to the seriousness of the charges that are before the court, the state is requesting a secured appearance bond. The state believes that $150,000 secured appearance bond is a reasonable bond setting given the nature of these charges and given the nature of these actions, Your Honor.
Thank you. Before I have defense counsel start, I do want to make clear for the record, the court has received, and at least it appears to be, there were 8 victim statements received previous to court. During court, the court's received an additional 4, although it believes one of these is a duplicate. The court has reviewed those. Although some of them say that the victims wish to speak, the victim advocate is here, and she's indicating that none of the victims or next of kin wish to speak, even though some of the forms indicated that they would be speaking during court.
And if I may briefly, Your Honor, on behalf of the victims, I have not read those victim impact statements. One can assume the impact. We know what the impact is. This is multiple individuals. This isn't just an impact to the families themselves, Your Honor. This is an impact to police officers who operate in the course of their duties every day with these kinds of dangerous conditions. And Again, condolences to the families and the impact here, but the impact is going to be significant not only to the families of the actual victims who are writing those letters, but to the state itself.
Thank you. Go ahead.
Just a couple items here. I'm not going to discuss the facts of the case. Obviously there's a Form 4 that was written for the court to make the decision today, and obviously the statements of the state. I'm going to speak to you in regards to the release conditions. There's release conditions are set, bond is posted, are put in place in order to secure the appearance of the defendant, in order to secure the safety of the community. And under these circumstances, I don't believe that that is an issue. He's self-employed. He's been living in the state of Arizona for nearly 40 years at this point in time. He's resided in the same home that he owns for the last 18 years. He's a licensed massage therapist. He owns his own business. He's a rehabilitation specialist. He's married with children. There's no prior criminal history. He's, at this point in time, not even a traffic ticket over the course of the last 10 years, Judge. We've had some medical issues that are being looked at. He's had a CAT scan. We're waiting for the results of that. We're not sure if that has any impact on this whatsoever. It's unfortunate what has occurred, but based upon the fact that everything that we have here on paper that you're seeing does not show that he's a flight risk. There's nothing to indicate that he would flee. There's nothing to indicate that he has a risk at this point in time that the community is willing to surrender his passport, is willing to surrender his driver's license if necessary, Judge. I'm asking the court to place him on pretrial services with ankle monitoring, home detention, however you want to do that, Judge. I don't believe at this point in time $150,000 is reasonable under the circumstances.
Thank you. The court has reviewed, as stated, the court has reviewed the victim impact statements, the Form 4. The court understands that the bond is set for a number of reasons. One of them is to assure the appearance of the accused. With respect to that, the court notes that the defendant does not have any criminal history known to the court, no felonies, no misdemeanor convictions at this time. The court does believe, though, these charges and allegations are incredibly serious, and that does impact the appearance of the accused. At this time, the court is going to set a secured appearance bond in the amount of $100,000. Sir, you are not to have any contact with any of the victims, any witnesses, any officers, or any next of kin. No drugs without a prescription, no alcohol, no driving without a valid driver's license, and for the time being, there is to be no driving, period. You must continue to provide the court with proof of your local address. The court will not be imposing any electronic monitoring, though that was requested by many of the victims and next of kin. Anything else to address then from the state at this time?
No, Your Honor.
Anything else from defense counsel? Sir, do you have any questions?